Hi, Clint Coons here with Anderson Business Advisors, and in this video we are going to discuss living trusts and having a proper estate plan. All right, let's get started. So, there's a lot of information out there on the internet how to properly plan for your estate. Maybe you've talked to your parents before or your friends and they've given you some advice. Well, I can tell you this, that there's a lot of misinformation, or people will steer you, I think, down the wrong road when it comes to estate planning, because maybe they just don't know or they have some other incentives in mind. Like, for example, if you go to an attorney and you ask them, how is the best way to plan for my estate? A lot of attorneys will tell you to create a will. Now, I'm sure many of you are familiar with the will and how it works. And if you're not, well, I'll give you a few examples here of how a will works. Typically, a will only operates when you die. So there's no benefit while you're alive to having a will. It's designed specifically that when you pass on, it's going to ensure that your estate is distributed to those beneficiaries who you designate in your will. Now, therein lies the problem. In order for the assets to get to your beneficiaries, A, you have to die, but B, you're going to have to go through probate, because that is the legal process through which a will operates. Now, if you haven't been through the probate process before, it's not an enjoyable experience, and here's why. Number one, you're going to need an attorney. Now, I don't know about you, but most attorneys do not come cheap, especially when it comes to probate. That's why so many of them will create wills for $200-$300 because they're viewed as a loss leader. That when you pass away, your family will come back to that attorney or their law firm and you'll ask them to handle the probate. And that's where they're going to cash in, because they're going to have to handle that filing for you, walking you through the entire process, which sometimes can take up to 9 months. Or if somebody's disputing it, we can be in probate for 3, 4, 5 years. Or maybe you have a rogue executor, someone that sees as an opportunity to make money off your estate, because they can charge to handle your estate if your will isn't set up appropriately or properly to stop them from charging. I know in my own family, my uncle charged over $75,000 to administer my grandmother's estate in a probate, and it took over almost 5 years, and all she had was 2 pieces of property and 5 financial accounts. So probate can create a lot of problems for people. So you want to avoid probate because of the cost, not to mention that it's public knowledge. Anybody wants to know what's in your estate, all they have to do is look at the public probate filing, and they can see it because it's all the public disclosure that comes with that. Now, there's other things as well that are negatives when it comes to probate, such as ancillary probate. Get this, if you're a real estate investor and you own property in 3 different states and you pass away and all you have is a will, you're rest assured that your family will be involved in triple the probate fees, because you cannot probate property in Florida if you live in California. You actually have to start a new probate in Florida just for that probate or that Florida property. Otherwise, there's no way that'll get passed on to your beneficiaries. So what I always tell people is that you should avoid the use of wills as your primary estate planning objective. What I like to use is a living trust. And the reason I like to use a living trust is that it bypasses probate altogether. Now, what's key here is you have to get this entity set up ahead of time. You have to set it up while you're alive, of course, and then you have to fund the trust. You know, people often say, well, how does that work? I said, well, I mean, it's a revocable document. So you set it up and you specify how you would like to have your estate distributed when you've passed on. And many times, the way it's set up, if they're a married couple, you'll have this one trust right here. It's called a joint trust. And it'll be for both spouses. And you'll put all of your assets into the joint trust, and then when the first spouse passes away, the survivor has it all. And then when the survivor passes away, then the assets will be distributed down to your beneficiaries. And this is where you put in a set of instructions on how they're to receive the funds. Maybe you don't want them to have all the funds outright. You want to stretch it out for a period of years. You can do that. You want to incentivize them to go to college, to start their own business. You can put all of that into the trust. So this is really important when you're thinking about your estate. Who do you want to receive your assets, and then how do you want them to receive them? For example, my son Carter is currently in law school, and my wife and I, Tracy, were out at dinner with him one night, and he said to me, brought up the estate plan of all things. He said, well, Dad, I know where the trust is located, but am I the trustee? And I started laughing. I said, what makes you think you would be the trustee? He said, well, I'm going to law school. I said, what does that mean? Your sister, she's not capable? And he said, well, she's not in law school. I said, so? Does that mean she's not capable? And he said, well, I might know more. And I said, no, you don't know what you don't know is the problem. I said, Carter, what is your experience in real estate? We have over 100 properties. How would you manage those? And he just looked at me. I said, okay, and I went on. I asked him a few more questions about real estate. And I said, Carter, most of our estate is real estate. You're not qualified to be the trustee. And he's just staring at me. And I said, that doesn't mean you'll never be qualified, but right now you're not. And so at a future date, when I think you're qualified, I can always change this document and make you the trustee, make your sister the trustee as well. So both of you will be together as co-trustees. But here's something else, Carter. You're not going to get all the assets outright because we have them held in trust for you and your sister's benefit for your lifetime and then your children's lifetime and their children's lifetime. Because what I'm building here is a legacy of wealth for you. I don't want you to be able to take all those assets out. And he's just staring at me, shocked that I would hold the assets in trust and not allow him to have them to do with what he wants. But I explained, I said, so many things can happen in your life. You could go through a divorce. You could be involved in a lawsuit. And then you could lose all of those assets. So what I want to do is preserve them for you to make sure that that doesn't happen. And more importantly, I want to ensure that you respect these assets, that you don't look at them as something to use to get a Mercedes SLK 500 or whatever the top of the line car is, because you think that is more valuable than having a piece of property that'll generate income for generations. So that is why we've created the trust in that manner. Now, I've just explained to you how I've created my trust in a simplistic term, but you can create yours any way you want. But as you see, is that it's very important that you have this set of instructions. Maybe you have children from a prior marriage, and we have other issues there as well that you want to take care of. So when the first spouse passes, maybe you want to ensure that assets are held over here for these children. So you can get as complicated as you want with this document. And that's why I tell people, this is the document you want to ensure that you create to hold all of your assets. And then when you've passed on, and then your spouse passes on, everything that's inside of here bypasses probate, and you don't need to bring an attorney in and pay the exorbitant fees to distribute out these assets to your beneficiaries per the terms of this trust agreement. Now, when I talk about holding the assets in the trust, what does that really mean? Well, let me put it in a different context for you. Think of it like this. Let's assume that you're going to move, and you've seen those pods before, right? That you can put all your stuff in. So here's your house right here, and you decide it's time to move. You're going to move to a new property. So you bring over one of these pods, and you take all of your effects into your house, all right? You put all your TVs inside of here. You put your couch inside of here as well. Your kitchen table with its chairs go inside of here. You name it. Your bed is inside of here. Everything you own is now placed inside of this pod. Now, when it's time to move it on, a truck comes over, picks up the pod, puts it on the truck, all right? And it's going to drive it to your new location. And all of your stuff is going to move along with that. Well, the pod, right, this is equal to a living trust. All right, it's just like a pod. What you want to do is you want to put all of your stuff into the living trust. So if you have LLCs, they're going to go inside of there. Your bank account will be inside of there. Your personal residence will be inside of there. Your corporation will be inside of there. All of those assets get stuck inside of that trust. So wherever you go during your lifetime, let's say I'm living in Washington right now, and then I move to Wyoming. All right, well, my living trust goes with me, and everything that's held inside of it will go to Wyoming or wherever you go. As long as you have your trust fully funded, then it holds. It's like a pod. It holds all that stuff. But let's say we take off and we forget to put inside our kid's bicycle, right? That's left outside of our pod. Now, what happens with that bicycle? Well, somebody's going to have to go and pick up this bike and catch up to the truck, move it over, and put it into the pod to make sure it gets to its final location. Well, it's the same way with the living trust. If you leave an item outside of your living trust, let's say we left outside of our living trust a secondary residence we have in Palm Springs, California. Well, all of these assets that are held inside of the box, they bypass probate altogether. No probate there. But this asset, since it wasn't inside of the living trust, this will have to go through probate. Now, we don't want to fall into that position if we don't have to. That's why you always want to make sure you get everything into your box, into your pod, so it just moves right on down the road and there's no hassle involved or no extra added cost. Because think about it, if you had to go hire a delivery man to go out and pick up this bicycle and catch up to the truck, he's going to charge you some money. Maybe he charges you $400 to pick up this bicycle to go catch up and put it in the pod. Same thing with this house for probate. What they're going to do is they're going to say, all right, well, everything's supposed to be in the trust because that's controlling how the assets are going on to the beneficiary. So we're going to probate this house and put it into the trust. We're going to catch up to where the trust's at and make sure it gets dumped inside of there. So whenever you create a estate plan, not only are you creating a living trust, you're also going to create a pour-over will. So this is a will right here as a backup document to handle the bicycles, the things that don't make it into the trust because you forgot to do it during your lifetime. In addition to that, you want to make sure that you have a living will in addition to your trust. So these are the other documents that every important estate plan should have. You want to have a living will. All right, that is a document that describes how your affairs should be handled in the event you're in an irreversible vegetative state. When I mean affairs, I mean personal affairs. Do you want to have hydration, food, pain medication? So this is important. When do you want them to pull the plug? You want to have a medical power of attorney. This is giving someone the power to deal with the doctor, to make medical decisions on your behalf. You want to have a financial power of attorney. Financial POA is going to give someone the ability to handle assets that are outside of your trust that were not placed in there and deal with those financial accounts when you're in a coma or you're unable to handle them on your own. So that's an important document to have. And as I said, you got to have the will. You want to have a schedule of gifts. This is really cool because with this document as well that goes in your estate plan, it takes care of all the little things. Let's say you have a watch or firearms and you want them to go to specific individuals when you passed away. Well, that's what you can do. You can put it down on the schedule of gifts. You write them out on there. And when you've passed on, then those are the gifts that get made first. Because you can't believe how many people fight over the stupidest things because they have sentimental value to them. So you want to make sure you have that addressed ahead of time before you pass, and you've listed that out during your lifetime, who is to receive those specific items. And the best part about it, you can change it at any time. And so if your kids start to ignore you, just say, hey, send them over a copy of the schedule of gifts and say, you know what, you used to be on here. Now you're not because I haven't seen you in 2 months. So there is some control there. Schedule of gifts, will, financial power of attorney, medical power of attorney, living will. These are all key documents every estate plan must have in addition to that most important living trust that bypasses probate, preserves your estate, allows you to control it after you've passed on by having provisions in there that describe how the assets will be distributed to your children. As real estate investors, I can't implore you that this is one of the most important documents you'll create because those assets that you're acquiring today, that you're building up, who is going to run them for your family in the future? That's going to be handled by your living trust. My name is Clint Coons with Anderson Business Advisors.